So hi, everyone. You don't know already, I'm Odette Dempsey-Caputo. I'm the senior lawyer at the Elizabeth Fry Legal Clinic, which is hosted by the Kamloops and District Elizabeth Fry Society. And we have a clinic also in Kelowna. So this is about sworn documents. Okay. These are the kind of just a little bit of agenda of what we're going to be going over in this presentation. What are sworn documents, when you should use them, why you should use them, who should you use them for, and how do you create them? Okay, so just hands up, who's used one before? And I'll get into what they are. I just was curious kind of what people are used to. So what is a sworn document? There are actually two types of sworn documents. So you have your affidavit and your statutory declaration. Your affidavits are sworn documents. So that's when you're saying, I swear or affirm that I'm telling the truth. And it's inside a court process. So that's when you're dealing with the CRT, small claims, Supreme Court of British Columbia, Supreme Court of Canada. Probably shouldn't be dealing with that one too much. And then there's the statutory declaration, which is a sworn document that's outside of the court process. So that would be your tribunals. So the Human Rights Tribunal, actually, you can use an affidavit as well because of the way they have it set up. But a lot of the tribunals, you're going to be using a statutory declaration. So for example, the RTB, Residential Tenancy Branch, is going to be one in particular that you would be calling that a stat dec, not an affidavit. Pretty much if you have a file number, we'll kind of go over what that kind of looks like. And if you look on Sketch, I gave some examples of an affidavit and a stat dec. And if I talk too fast, just let me know. So the next question is, when do you want to use a sworn document? And I'm just going to put this out. Anytime your client needs to give evidence can be really handy if the tribunal allows you to. So it can benefit applications like CPP, disability, people with disability, they're on persons with disability, income assistance, all of those kinds of things. It can even be helpful for insurance companies. If you need something where they're asking you for some information and there might not be a hearing or maybe there's one coming up, you're really going to want to use these sworn documents to get that evidence out. So tribunals, all the different tribunals here, you're going to use them for, and then other things like ID or medical benefits, or even a witness. So one of the things we see a lot in the residential tenancy branch is witnesses who've given letters. Some arbitrators give that weight. I mean, obviously we would say you prefer to have the witness there on the phone call. But if you do a sworn document, I've actually found that a lot of the arbitrators will accept that evidence a lot more than if they are just like a letter, right? So you get that kind of sworn document done and hand that in even from witnesses. It can be very helpful. It also really gets a lot of times, whoever's doing these documents will actually have like a better idea of kind of what's going on. So why do you want to use a sworn document? So I kind of alluded to some of this already, but I'm going to say efficiency. So one of the things by using a sworn document in these different settings is you've actually set everything out. So now you're not having to restate this information. Unlike a lot of other times when you put in evidence, you have to refer to it. If you've done a sworn document, often you won't have to talk about what's in that sworn document. You can just allude to it. You don't have to have, if it's an RTB, for example, and your client's there and they've done a sworn document, you don't have to get them on the record explaining the whole situation again, which can be really helpful. You can just give submissions around it. It can be really helpful when the RTB, as we know, is giving you 1 hour, and some arbitrators are very strict and won't allow you to do anything more than that hour. It gives whoever's the decision maker familiarity of the case. So instead of just showing up the hearing, and this is the first time they're kind of finding out what's happening and what's kind of occurred, they have an idea of what kind of evidence is going to be presented to them. They understand what these pictures are that you uploaded. They're not just like, oh, why is there this picture of, black spots on the window or black spots in the wall? They kind of have an idea. Clarity. I'm sure for those advocates that have been doing this for a while, our clients are not always the best at telling their story. They can be all over the place. They'll start in 1980, even though they were never in that rental until 2007. This kind of allows the clients to, not only does it help them kind of understand what their case is about, but it also gives some clarity to the decision maker. So the decision maker kind of understands what's going on, and it can be done in a way with your help, right? Where it's set out in a very logical way. And again, it helps clients, right? It helps clients understand their story. It helps them understand what they're going to say. It can take, especially if you have a client that gets really nervous or something, it can help them know, what their evidence is already there, and they might not have to talk as much. So just dealing when I'm talking about helping the clients, you might want to use it if your client has mental health issues, right? Sometimes maybe they present differently one day than another day, or they may have a lot of insecurities about talking on the phone or in a video conferencing, depending on how the tribunal is being done. Talk too much, that's one of my faults, right? So if you were I was your client, you might want to do a sworn document to help me not talk too much. I'm sure, especially when you have those tribunals that limit the amount of time or the court time, and they get frustrated because they're just going on and on and on about the same issue and they've already made their point. Clients that have trouble with chronology, I had one where it was income assistance where they were saying that the client had quit because of harassment, but the client couldn't actually describe what happened, what the harassment was. They would just say, oh, this person harassed me. And it was a lot of work to get that out of the client to what the harassment actually was, because they were such a poor kind of storyteller in what the chronology happened. So by putting it in a sworn document, you can kind of get that order of when events happened. I have a lot of clients that do that. They talk about June one moment, and then they talk about January the next, and then they've jumped over to August and you have no idea what's going on. If someone has a processing disorder, it can be very helpful for them as well, because you kind of work them through that, and then they're not doing that kind of in that moment. I mean, remember, we may be very used to going to these hearings or going to court. Our clients are not, right? This might be their first experience, or their experiences in the past have been very bad, right? They've had very bad experiences with decision makers. If the client is loud, it can be very helpful, especially if you're meeting in person. If you can kind of lower that down. I've had situations, and I hate to say it, but I think especially with males, if you're very tall and you can come across as very aggressive and you're loud, you're not even being aggressive, just your mere presence can be very intimidating. So sometimes by having a sworn document, you kind of remove that. You're getting that evidence done in a way that the person's not, screaming or yelling or getting upset. And if the client's untrusting, right, it can really help them to see what their evidence is, and then you can have them look it over, and it can remove some of that concern about being on the video conferencing or being on teleconferencing where they're trying to talk. So that's kind of just an overview of some of the reasons why you might want to do it. So then the big question, how do you draft a sworn document? And I'm going to tell you, you could literally spend hours going over this. I could probably spend 2 days. I'm trying to go through this a little quicker so we can spend some time practicing it and stuff like that. But sworn documents can be, it's quite the skill. And the more you do it, the better you become at it. I also recommend reading other people's affidavits. I've learned from other lawyers' affidavits. I know that both good and bad, I've definitely had those affidavits where I'm like, oh, this isn't going too well. So it's really important to kind of learn how. So I'm just going to show this. I don't know how well it's showing up on there, but these are kind of some of the terms that you'll see with affidavits and stat decks. So first you have to have who the person is who's declaring it. So who's swearing this? Who is that person? That person is your affiant or your declarant, right? And so in the example that I gave on Sketch, that's Donald Duck, right? That's a Donald Duck swearing this. The style of cause. So if you're in a court, it will look much differently. It might say there's forms for this. So you want to look at the forms of what their style of clause should look like. So I did this one with the stat deck just to show it. And you would do something similar with the RTB where you kind of have it set up this way. So this is the caption at the top of the document. And so it's really telling what file is this in reference to, what type of file is this in reference to, so that when you're filing this document, whether it's the RTB, HRT, they know where this document belongs. And it's very different for an affidavit versus a statutory declaration. So that's kind of how you have to look at the difference. This one right here, I just showed it because this is how you would do it for the residential tenancy branch or an insurance, or if you're just, trying to send it off for some government where you're not actually in court. Then you have the introduction. So you have to have the person who's swearing it, you want their name, you need their occupation, and you need your address. Now, if it's a situation where they're really nervous about putting their address in, you can get away with just putting the city. If it's a domestic violence, if you're in family law or something like that, there are ways to get around this where you could put something in there saying, I don't, or you put your own address, like the business address, and you make it clear in there. But so there are ways around it, but generally it should be the address and then the connection to the issue. Why is this person swearing this? Where does their knowledge come from, right? Well, I'm the claimant, so of course I know what's going on, or I'm the tenant, or I'm the neighbor. You kind of need to set that stage of why is this person the person that's swearing this document? So then one of the things, they must be sworn and affirmed in front of the commissioner. I was just talking about this. Lawyers are horrendous for this, and they shouldn't be. There's lawyers out there, they'll sign it and then they'll come to you as a commissioner and they'll be like, oh, can you swear this? And I'm like, no, I can't actually. You didn't sign it in front of me. So it's kind of similar to, I would say, a will situation where everyone has to be in the same room. So the person who's swearing or affirming the document has to be there in front of the person, the commissioner. And I know some of the advocates have that commissioner, so they should know that. You can see in here that the commissioner must print their name below. That's so we know who it is. We know you didn't just go to your neighbor and was like, hey, can you pretend to be a commissioner? You can write below, that you're a commissioner, but usually they have stamps. They have a nice little stamp, they stamp it, and all the information's in there. The commissioner signs after the person who's affirming it, right? So they will affirm that's the truth and that nothing in there is there. And really smart idea to tell your clients that this is similar to giving evidence in court so that they understand the seriousness of swearing these documents, and get them to read it. Okay. And if you change something in it, get them to read it again. I don't care if all you changed was the name of a spelling, you need to do that so that they know it's the same document, and they have to see the exhibits as well, which we're going to get into. So all of those things must be done together. So the commissioner signs, and they including the exhibits. So we'll get into that where you'll see the exhibit sign, and you're actually the commissioner signing each one of those, and you go through each one of those things. Now, if there was a mistake and it's a small mistake, and you can cross it out and write in the mistake, but then both the commissioner and the person who's swearing it have to initial that change was made. That way we just don't have things being changed after the fact. Also, and I get into this later, but numbering pages can be really helpful as well. So exhibits. In the example that I put in there, this is one of the exhibits showing the broken vase, a picture of the broken vase. So exhibits are documents that you're attaching on that you're describing in the original sworn document. So of course, when you're talking about the picture, you're not going to slap it right in there in the document between paragraph, 5 and 6. You're going to say attached here to as exhibit, A is a true copy of a picture of the broken vase. And you can see that in examples that I put there. You can see it up there under 11, and that's just to allow the person to flip to the back, right? And see what that exhibit is without creating like this big long document that can be confusing. You need to mention it in the sworn document, as I said, and then attach it to the end of the sworn document in alphabetical order. So it is done A, B, C, D. And if you have enough, hopefully you don't, then it would be A, B, B, C, C. Hopefully you're not getting that many of exhibits. I would highly recommend that you likely lower those down. Now, that being said, like if you have like a group of pictures, you don't need to put as each individual picture as an exhibit. So let's say you had an RTB one, you might want to have them differently. You might say, attach here to are true copies of pictures of the kitchen, and then you'd have all the kitchen photos. Attach here to as exhibit B is pictures of the living room, and then you'd have all the living room photos. Or you could say attached here to is true copies of, the rental unit, right? So you can make those choices to what's going to work best for your evidence. If you're talking about just the kitchen, then you're just going to attach the kitchen photos. And this is what I'm talking about, where it really helps you organize is how you're presenting these different exhibits. It can be quite helpful and makes things very easy. So things to include in your affidavit: numbered paragraphs. So as you saw in the example, it goes 1, 2, and then you go down. Number your pages. So generally, if you're using a Word document, you can put in those Word pages, and then you're like, well, now I have these exhibits, and you just attach in the back. You start off, so if your affidavit ends at page 5, then the first exhibit's page 6, and you write it in the kind of bottom corner and you circle it, and then you keep going. The reason why you want to do that is because if you're in court or you're before a tribunal and you want to refer to that exhibit, you can say, oh, the pictures of the kitchen are starting at page 12. They're exhibit B starting on page 12, and then they can just flip it. It's more ease of reference. It's not that they won't accept this. This is just good practice to make it as easy as possible. Each paragraph is one sentence where possible. One of the biggest mistakes people make drafting sworn documents is they like to put big paragraphs of information. Really, it should be 1, at most 2 sentences in each of those numbered paragraphs. So it's more like numbered sentences, but you're putting them individually. If you put too much in, if, for example, the court doesn't agree with something, they'll strike the whole paragraph instead of just a sentence. It also makes it easier for reference when you're talking about things. And then when you're referring to it in your submissions, if you're talking about, for example, the kitchen, you might say paragraphs 13 to 16 describe the damage that was done to the kitchen. So you can do that, but just be aware that it should be 1 sentence where possible. You can use headings. So you can say, tenancy agreement, and then you would just bold it. You don't need to make that a number, but you would just use a heading there. And that can also be helpful to kind of break it up. And avoid using and, slash, or. Just a little tip there. Not something you really should be using. It should be one or the other. This is a document where you're telling the truth. I should go back. When sometimes clients get really nervous and they're like, I'm not sure about the date. I don't really know when this happened. So you might use N, on or about, December 12th, 2021. You can use that kind of language. I might say in the spring of, so you're kind of narrowing down the time. It doesn't have to be exact. And really what they're trying to do is, to the best of their abilities, tell the truth. So it's not like something comes out and it's completely wrong and you're like, well, that's what the client thought. Well, that doesn't mean that they didn't tell the truth. They were telling to the best of their abilities. Maybe that's what they understood was happening, or they understood was going on. You want to tell a story. This is the most important thing when you're doing a sworn document, is you're telling a story. What evidence is important for that decision maker to know, right? And it's from the perspective of your client. So they're using I. You don't want to say, you're not going to say, Mr. Smith, right? If your client's Mr. Smith, it would be I, because it's from their perspective. It's them telling a story. You're just helping them tell that story. And you're going to tell it most often in chronological order, because that's going to make the most sense. There might be times where you wouldn't, but I would say you're going to lean more in that chronological order thing. This is when they moved into the rental. This is how it happened. Then they started getting, notices, and then they got the eviction. And then this is what happened after they got the eviction. That's a kind of, chronological order. Use language people can understand, right? If you're somebody who tends to use big words and your client's not, well, then it's not in your client's words, right? It doesn't have to be exactly in their words. You can guide them a certain amount, but you shouldn't be using legal terms. Clients don't understand that. They're not going to use terms like the best interest of. So you want to keep it simple. You don't want to repeat. This happens a lot. So if you do those headings, don't repeat the same evidence later on, right? It gets very confusing to decision makers and it gets very tedious. Your job with this is to make it as easy as possible for the decision maker. The easier you make it for them, the more they tend to be on your side, right? Because they're understanding it. You're basically trying to make it so that your evidence comes across as easy as possible for them so they understand what's going on. Because if one side they don't understand what's going on and the other side they do, they're more likely to lean to the one that they do understand versus the one that they don't. Check for spelling, logic, and facts, right? If our clients sometimes like to put illogical arguments out there, sometimes we have to rein them in. I had one that was pretty determined that their neighbor could see through walls. We very delicately had to explain to the client we weren't going to put that in the stat deck. Very good one to put in a stat deck, because you can imagine if you got to an RTB hearing and the client starts going off about how the neighbor can see through the walls, we've now lost credibility, right? So by putting in a stat deck, that's a good example of a mental health issue where we're able to put in they had a legitimate claim. There was actual stuff going on, right? That had the claim to go to the RTB. It's just that they couldn't articulate that evidence in a way without undermining their credibility. So, like I said, if you're telling a story, you need to know why are you drafting it? What's the point you're trying to get at? I'm going to keep drilling that in. That's really what you're trying to do. Why are you drafting this? Know who's signing it, right? Is it a witness? Is it your client? Write in first person, what I've already told you. Use the person's own language to the best of your ability. Use the person's name when you're referring to affidavit. When I say that, if you're referring to a neighbor, if they're referring to a neighbor, you always want to use the person's name, because sometimes we think we know when we say she that we mean the neighbor we talked to about in the sentence before, but that doesn't mean that the arbitrator knows who the she is, because maybe there's 10 she's on this file, or there's like a few he's. Like we don't know who that is. So you should always be referring to the person so that we know. So that's why you're going to use I, or you're going to use the person's name. In affidavits and stat decks, you can use the person's first name if that's how the person refers to it, or if the person, has maybe they call this person Granny, right? If you're going to do that, you need to define who Granny is. Meaning earlier on the affidavit, you need to say, Granny is, the person's name. And then the decision maker understands that that's who you're talking about when you say Granny. But that would be using the person's language, right? Because that's what they talk about. They're not going to talk about their neighbor or their spouse by their last name, right? So when you're giving your submissions, you're using the last name, but in the affidavit, you're not. Yeah. Then you say the neighbor. You can totally say the neighbor. It's totally fine. Sometimes what we do, and I can't remember if I put it in here, but we'll have like little brackets and we'll put the quotations neighbor, and that's like defining it. And then you can use neighbor throughout, but you always have to use it in a capitalized way so that they know you're not talking about the other neighbor, the other side. But generally, yeah, you can use it. You're using what the client calls them, right? That's using their language, what they know that person's called. I mean, not if they're using swear words or inappropriate words. I've had that too, where, you get a racist client, I don't recommend using the racist term that they're like, stay away from that. Of course, I mean, I'm sure you all have common sense, but I want to be clear, like that's not the time you use their language. But generally you're going to use kind of what they would say. Don't over exaggerate. This is something that decision makers pick up on really quickly. And that's what I mean by don't use intensifiers, right? It's not very, they were very angry, or they were very, you need to be careful about using that, right? Because you're trying to describe a story. Don't give opinions. So affidavits aren't about opinions. You can't say something like, I know my neighbor did this because they're mad that I did this thing over at this time. Unless the neighbor told them that, that's not evidence. They don't know that, right? Unless you can say, I believe this happened, even then you have to be really, really careful about that. You shouldn't be really giving opinions. You shouldn't be giving conclusions. So you can't say, I was wrongfully evicted, right? You paint the story about why you're wrongfully evicted, but you don't say that. That is the decision maker's That's their job to make that conclusion, not yours. And you don't include arguments, meaning you're not making the legal arguments within the stat deck or the affidavit. Now, I highly recommend if there's a test that you need to meet, right? Like we all know that when you get an eviction, you have so many days to hand that in. You might say, oh, we filed in this time, but you're not going to say we filed in time. You're going to say, oh, we filed on this day, which shows that you did it within the 10 days, right? We were served this day. We filed by this date. You're not going to say I filed in the 10 days. You're just going to lay out the story showing that you filed within that 10 days, if that makes sense. Unless the other side has clearly said you hadn't and you need to prove like what the date is, but you're not going to make those arguments. Again, don't repeat yourself. I'm repeating myself. Don't you do that. And don't include information that's not relevant. We all know that. Our clients love to talk about all kinds of things. If we're talking about eviction, it doesn't matter that their landlord didn't fix their stairs, right? That's irrelevant if all we're doing is disputing the eviction. It's irrelevant. Don't put that in there. You're just creating a lot of like airspace, right? And you're putting a lot of information in there and you're losing a little bit of your credibility. Don't hearsay. So hearsay is like, maybe some of you know this, but hearsay is when you're saying something that you were told, right? So if I say, you know, oh, Nadine told me this, you don't say that in an affidavit or a sworn document. You avoid that at all costs. You may say, and if you do have to do that, then you have to say something like, and I believe it's true because, right? Because it's not strong evidence. You need to show why you believe what that person told you. It could be relevant, and this is where you avoid hearsay. It could be relevant if you were like, oh, I picked my child up early because the school told me they were sick. Well, then it's relevant to the story, right? It's not hearsay. You're not trying to prove that the child was sick. You're just saying, oh, this is what someone told me and that's why I reacted that way. But be very, very careful when you're putting in a sworn document what someone else said, right? You can't say, oh, the neighbor told me that the landlord came and stole my mail. You know, well, then the neighbor should be swearing that sworn document, not you, because you didn't see it, right? And it shouldn't be accepted. Most tribunals won't. We all know the residential tenancy branch has their, they may or may not, we never know. I have successfully argued against hearsay at the RTB. Like I said, be really careful attaching letters from witnesses, right? People do that even to the affidavit. Landlords do it, tenants do it, but it's not the best evidence. Your evidence is going to be stronger than the other side. If they have all letters that people have just submitted and you've submitted sworn documents, your evidence carries what we call more weight, right? And don't use legalese or legal concepts, right? And you guys probably don't have as much trouble with that as the rest of as lawyers do. We're really good at using legal concepts and we don't even realize we're using them half the time. We're using all kinds of concepts. So I did, and I know I'm kind of rushing through this, but I just wanted to give time for us to kind of practice and do some things. And I know it's the end of the day. Does anyone have any questions before we kind of go on to practice? Yes.
So for me, when I'm submitting evidence, I like to try to kind of separate what the tenant wants to submit as evidence and then my stuff. Like I like to point out the legislation. I like to point out sometimes arguments that I'm planning to make that I'm okay with the landlord knowing in advance. And the way I set up that package, I always basically refer to letters and stuff as the evidence and attach it to what I'm putting in. So in this case, would I be best to like get my client to create their affidavit to have their statement and then refer to it as part of what I normally would do is I call the evidence package in a whole.
So when you're saying your arguments, that's your submissions. So what you're putting in there is submissions, right? So then you would refer, you can refer to evidence that you've uploaded. You can refer, it'd probably be better, more proper in a sworn document, right? And then you refer to, oh, as set out in paragraph 38 of so-and-so's stat deck or exhibit D, right? So
Mhm.
you refer to that in your submissions, but your submissions are not sworn. You can make
Yeah.
all the legal arguments you want in there. You can say whatever you want in there.
Exactly. That's why I just wanted to kind of clarify. The tenant or the
Yeah.
client is swearing their stuff. I'm not technically part of that other than signing off on it if I'm the commissioner. But my stuff, I don't need to
Yeah.
kind of swear, and I kind of refer to their stuff as additional evidence to my arguments.
And I'm actually going to say, when you're doing your submissions, if you have a sworn document with all that kind of exhibits attached, it actually makes more sense than the arbitrator having to like open up this. Because I've seen advocates where they upload it as exhibit A, exhibit B, each separately.
Mhm.
Well, now every time the arbitrator wants to refer to that, they have to open up a new document, right? But if you have it all in a sworn document, you're like, oh yeah, exhibit A at page 14, and they're just scrolling down. You've now made it way easier for them.
That's
to
actually more of
do
a
it.
limitation on the RTB side. Their file limit size
know.
doesn't always let you get
Okay, fair.
everything in one document.
You can separate them. You could do that, right? But technically, if you could put like just the affidavit and then the exhibits if you needed to. You can split those two and just say affidavit part 1, affidavit part 2, or sworn document part 1, sworn document part 2. I have run into that issue. If you call them though, you can upload it.
Really? Okay.
Yeah.
I'll have to try that.
Don't I haven't personally done it, my assistant or my advocate. So if you run into issues, don't come after me. But I have known that we've had those issues and they have allowed us to upload, but you have to call the head, right? And they give, I don't know what they do. I get other people to do that.
I'll have to give it a try.
I'm a lawyer. I'm incompetent with those things.
Thanks.
Any other questions? Is there any online? Okay. So I have some that are on slides, and then I have one that we can do that we'll put up later that you guys can actually practice doing it. But these are kind of like identifying, this one's going to be kind of identifying the mistakes, right? That are in these ones. And then I have one where you guys can actually, I'm giving you a scenario and you can try to draft an affidavit from it, right? To kind of do those points. So the first one, Huey was mad at Dewey and wanted to attack him. Louis told me that they had been fighting all day. Huey and Dewey always fight. So what's wrong with this? So this would be like 1. Sorry? I can't hear, so I apologize.
You told me that they had been
Right?
fighting all day. Yeah.
So Louis told me, hearsay, right there. Louis told me that they'd been fighting all day. Why is Louis saying that? Right? Louis should be swearing the document. Anything else? Yes.
Dewey was mad at Dewey and wanted to attack him.
Yeah.
Yeah, that just seems like almost like an opinion.
It is an opinion.
Yeah.
So instead of saying Huey was mad at Dewey, you're not supposed to, that's you giving your opinion. You don't know that person was mad. What you can say is you could say something, they appeared mad and this is why. Or better yet would be, Huey's face was red and he was clenching his fists. And you know what I mean? That's what I'm talking about, telling that story. Because when I'm saying that, his eyebrows were, his forehead was crunched and he was clenching his fists and he was raising his voice. You all have an image of this person now being angry. I didn't say they were angry, but that image has been created in your head. So that's what you're supposed to be doing in a sworn document, right? Is creating that image without actually giving the opinion. Anything else? Yep, that's the other one, right? Huey and Dewey always fight. That's an intensifier. That's like do they always, what's the relevancy? Who cares if they always fight? Who cares if they fought yesterday? Who cares if they fight tomorrow? We're not talking about that. We're talking about what happened right now, right? So why does that matter? Yeah, no problem. Sorry, there's noise right here. So I'm actually I have hearing aids. So when my hearing aids are picking up the noise over here.
That's okay. So how do you know, how do you make sure that you're not leading your client in their statement? Because you're supposed to be using their words, right?
So it is hard. Sometimes I'll have a client write out their statement and then I use their statement to create the sworn document, right? I mean, obviously you are kind of helping them along, but yeah, you're not telling your client what to say. You're not saying, but you're saying, hey, instead of saying he was mad, how do you know he was mad? Like, you'll ask them that question, right?
Right.
How do you know they were mad? And then they'll tell you. But we don't talk like that in general, right? We don't talk about like that to each other. And your client's going to talk to you, is going to write down their statement as if they're talking to you, right? Unfortunately, that's not how it plays out when you go to a tribunal or a court, right?
Exactly.
So I was just going to say something that I learned over the years, which is to avoid always and never.
Yep.
Because people will say they always do this. And then one example where they didn't makes your evidence weaker, or they never ever helped with something. And one good example that they did help with something weakens the evidence of your clients. So helping them to avoid the always and never is always to be avoided and never to be done. That's it.
So you can see I've like put this up, right? They use conclusions, mad, wanted to attack. Well, how do you know they wanted to attack? What indication? Like, why are you saying that? You don't know what someone else is feeling. You don't know what someone else's intentions are. You can describe things, but you can't know. Hearsay, already pointed out, Louis told me, not relevant. They always fight. Doesn't matter. It's one big paragraph, right? You could be splitting that into 3 different ones. One big paragraph. And they use they instead of Huey and Dewey. Now, in this scenario, because it's one big paragraph, it makes a little more sense, but who is they, right? So you want to use it. So you would split this into 2 different kind of sentences that way to make it a little bit easier to understand. And I realize I'm actually simplifying a lot of this stuff because you could spend a long time. CLEBC does like, I think, a 2-day thing on affidavits. So practice 2. This is the next one. What's wrong with this one? You can take a few minutes. You have an answer, feel free to put up your hand. Legalese. Where's the legalese? Actus reus and mens rea. How many of you guys even know what actus reus and mens rea is? You might not. Right? Most people don't. Nobody talks like that. Crown might. Police officers might. But generally, actus reus and mens, what does that mean? Right? Why are we saying people don't talk like that? What's another one? Anyone else can think of anything? Always, right? We just heard about it. Never use always. Or never. Yep. Yeah, how do you know? You're drawing a conclusion there, an opinion. How do you know? Right? Plus, I mean, who is always hitting what's the relevancy? It doesn't matter. We don't care that they used to always hit. What we care about is, what's happening in that event. Anything else?
It says that the assault on Dewey, but there's no mention of someone being hit. It just says always hitting, but there wasn't a mention
Right?
that it transpired.
You're missing some I don't even think I have that in the next part. Good catch. Right? So the describing of the intent meant to. Your clients will say that all the time. That landlord meant to do that. They did this because I stepped in their garden and now they're after me and that's what they're doing. I mean, we know that, right? And especially if you're dealing with clients with mental health issues, there's a lot of paranoia that goes around that. And so there's a lot of of that kind of implying intention on people. So it's one that you really need to be careful about. Anything else?
Just the last one with the never liked the vase. What relevant does that have?
right?
Yeah.
And how do you know? How do you know what they liked or didn't like and it's irrelevant? So this is what I pointed out, right? Used an intensifier always. Use legalese, second paragraph. Also not simple language. We always want to be simple. My big thing is when you're speaking or you're drafting these things, you really should, 80 to 95% of the population should understand what you're saying. When I taught law students, we used to tell them, I mean, I felt really bad. We spent all this time teaching them to write academically, and then they get to the legal clinic and we're like, FYI, can you please draft your letter at a grade 9 level? And it really should be lower, grade 6. If you're in Word, you can actually get the grade level. It will actually tell you what grade level you're writing at. And if you go in, you can Google it. I know how to do it. I'm not good at describing it. Just be careful if your client has any kind of, we had a student whose name was Nikita, and just by removing her name Nikita, it went from a grade 12 to a grade 9. So apparently they didn't understand that. But you can check that out. Like, it should be in that simple language, not only for the sake of your client, but it's just easier for people to understand. Includes a conclusion, meant to, never liked the vase, right? And a lot of other things that we've already pointed out. I think we have if we can put up the assignment, and then I have a bigger one that you guys can just spend some time. I wanted to give you guys lots of time to kind of just practice drafting an affidavit. If you want, I can come, or you guys can just do it amongst yourself. If you have any questions, kind of ask me, or you can propose what you think should come in this assignment or exercise, I think I called it. I knew this was at the end, so I wanted to make it very nice and easy. So there's the exercise.
Is it a different one? Different PDF document?
I don't have any other. I think that's it.
This is it, right? Okay.
Yeah.
I will drop into the chat for the online participants.
Perfect. Someone just pointed out, just to let you guys know, that sometimes you actually can have a little bit of a longer paragraph. If you're saying that on such and such a date, the following things happened, you might then go A, B, C, D, right? So you can do that. I don't want you to think that like you can only do one sentence per thing. It's just that you don't want those big block paragraphs of information. You will find lawyers that do it as well. And like when we were talking about story, I know this is a family law context, but we had an affidavit recently from a lawyer on the other side. It was from their client that was so in family law, it's always about the best interest of the child, but the affidavit was very much how the denial of parenting time was affecting the parent, right? So that's when they're missing the point of the affidavit, because the judge doesn't want to hear how it's affecting the parent. They want to hear how it's affecting the child. And it was very, very parent centered. So that's when you kind of want to think about these affidavits and be like, what am I trying to get across, right? What do I want the decision maker to learn about that, right? And so in a case of family law, you're trying to go from, okay, why is this detrimental to the child? What's kind of going on? How is this affecting the child, right? I should say in family law, hearsay is allowed a little bit more when it's a child. So it's not the best example, but I just wanted to put out there that you can have those bigger paragraphs. You just have to be careful with them. You can go A, B, C, D. And it's up to you guys how you want to proceed. If you want to just kind of do this, and then I can post an example later. If you want to talk about it in a few minutes, just let me know how you want to proceed this, because I know it's at the end of this whole session. So it's completely on how you guys would like this to proceed. Okay. I'll see if I can see it on here. So just to kind of go over this, I am going to put up a sample of this one, but if anyone wants to kind of point out, so because I don't have it right in front of me. So what you're going to attach as exhibits, of course, is going to be your rental agreement, right? Number one, rental agreement. You're probably going to put in your any kind of medical documentation proving that you actually need the medical one. You're also going to anything else that may come through that, right? You might want to put pictures of what you're doing in the wintertime for air purifying, right? You might want to do that. Say, okay, this is what I'm doing to purify the air. If the neighbor, sometimes the landlords say the neighbor said something when they didn't. Maybe the neighbor is friendly to you, so you might get a stat deck from them saying they don't actually care about this kind of stuff, or that they don't see this happening, or they don't have any issues. You're going to, of course, go through each one of those things. So you can actually you can say, you don't need to you can refer to yourself, right? You can say what your intentions were. So I am doing the purifier in there so that the air is cleaner. You can put in there that you do have arthritis and severe anxiety. So if you didn't have a medical, that might be enough evidence for the decision maker, but generally they like supporting evidence. It could be a doctor's note. You're going to set chronologically. So you're going to say, I am the tenant at this address, right? We know this when we would try, they always ask these questions. I started this tenancy on this year. Then you're going to go into, I have been smoking in the place this entire time. Then you go, the landlord on this date said this to me. The landlord on this date put the note. You're going to have the note as the exhibit, right? That's going to be another exhibit. You're going to do that kind of in order of how things are going. You're not, you're going to say, he seemed very angry and rushed into the basement suite. Don't put that direct. You know how we're talking about the client's giving you a statement? So that would be the case where you're going to say to the client, watch out for that one. That's a trick where you're going to say to the client, well, how do you know that he was very angry, right? And rushed into the basement suite. So you might say, again, clenched fists, angry face, stern, not angry face, but you're going to say the wrinkled brows. You're going to describe how you know that. Raised voice, different demeanor than before, and this is how it was different. Maybe the person looks a little bit different than they normally do. I'm trying to go over this quickly. If anyone has any other questions around it or comments online, you can say it. So when you say Polly will not stop smoking as it's not in her rental agreement, that's your client. Your client can say that. I know that's an intention, but your client can actually put that in. I'm not going to stop. It's in my rental agreement. There's nothing in my rental agreement that says I can't smoke. So your client can actually say that. So your client's intentions are fine because they know what their intention is. It's when they were referring to other people. You'd want to put in that it had been 5 years, but you're going to put that earlier. This is when they started. It had been 5 years. You can do the math for the average. That's fine. That's not a conclusion. You can write that math. If you're going to say she tried to smoke less and less in the rental, I wouldn't just put that in there. That's kind of vague. What do you mean less and less? What I would actually go into, I used to smoke 5 times a day in the rental. Now I only do it when I first wake up, and then I try to go across the street and do it all the other times, so only it's show the progression, right? So the client's not really giving enough information here, and you kind of want to go into that. So when you read this, you're going to be, what would I want to know if I was the decision maker? So draft your affidavit, go back. What would I want to know? What do I not want to know? What do I need to know? You would put in there during the summer, she smokes near the open window. You could show a picture of that. You might not need a picture of that. So you can see she has given you a copy of the rental agreement, 1 month notice of eviction, and 2 notes. So those are all going to be exhibits. In this case, with the 2 notes, I wouldn't attach the notes as the same exhibit. I would actually separate them in this case because they happened at 2 different times, right? So let's say they gave a whole notes and a whole pile of stuff at once as a package the landlord gave you, then you might attach that as an exhibit all at one time. But because these notes were given at different days, you would actually put them in as different exhibits and explain what they are. You filed the dispute notice of eviction on time. You're not going to write that. You're going to say, hey, I filed it on this date, right? This was filed on this date. It was served on this date. Now they're going to ask you that anyways. It just helps the arbitrator not have to ask that. And like I said, when you're in a rental, they limit it to that 1 hour, right? So this, and and I appreciate there's like, we've been doing judicial reviews. You just don't want to have to go to judicial review to say there's procedural unfairness, right? So if you can slow down, like get as much evidence as you can before you're actually before that decision maker, it can be very helpful. And in this case, sometimes if it's like more complicated kind of what's going on, it can be really good to do stat deck. I don't know, like if you ever had someone tell you a story and you're having trouble following it because it's like such a long story or you've kind of zoned them out, stat decks make that a lot easier. Because then if they forget something you said, it's written down before them, right? It's not their notes they're relying on. They're relying on your stat deck that you had more control of what evidence goes in too, right? Like I said, you really don't want your tenant to start talking about how the landlord can see through the windows or about how their dog that passed away 6 years came to visit them. These are legitimate things clients have told me. So I will put it up there. Is there anything else like anyone online wants to point out or anyone else wants to point out how they might address this? Nope. Okay. And yeah, thanks.